Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case NFIB versus OSHA. This case was heard in the Supreme Court of the United States in the year 2022. Let's go ahead and jump into the facts of the case. So this case is about the widely controversial President Biden's OSHA vaccine, mask, or test requirement. And so we probably all know what this was and what this was about, but just for posterity's sake, I'm just going to briefly explain what it is. So this emergency temporary standard was enacted by OSHA in November of 2021 in response to COVID-19. And essentially, the idea was that OSHA was going to require employers to either force the employees to show them their vaccination status, or force the employees to show them that they tested negative, and then force those employees that were unvaccinated to mask while they're at work. And so that was essentially the standard. Your employees either get the option of vaccinating or testing and masking. And it is the job, basically, of the employer to enforce this regulation on their employees, and it applies to all employers that have more than 100 employees. So essentially, this was very forward. The Biden administration was trying to get vaccination rates up to try and combat the COVID-19 crisis. So what's the procedural posture of this case? We've already discussed a similar case on this channel a while ago in the Fifth Circuit, where the Fifth Circuit issued a stay. Well, after that stay was issued by the Fifth Circuit, all of these challenges to this emergency temporary standard were consolidated in the Sixth Circuit via a circuit court lottery. Now, conservatives at the beginning saw the Sixth Circuit to be kind of a positive thing for them, and they thought they were going to win this case in the Sixth Circuit. Well, the Sixth Circuit, shortly after it got transferred to that circuit, vacated the stay and essentially said, you know what? This OSHA ETS is going to go into effect. We don't think that the plaintiffs are going to win this outright, so we're not going to enforce this stay. We're not going to put that into place. So that puts everyone up in arms because it looks like it's going the other way. It looks like it's going in President Biden's favor. So the plaintiffs appeal to the Supreme Court of the United States, and they're essentially asking for this stay back, saying, give us this stay, tell the lower court that we're going to win, and make this all go away. That's what they're asking the Supreme Court for. And the Supreme Court does just that. The per curiam decision, which that means is not authored by any specific justice, but it was endorsed by the 6 conservative justices, essentially says that OSHA did not have the statutory authority to do what it did here. OSHA's Enabling Act, so the act that created OSHA and gave OSHA the ability to enact these emergency temporary standards, the court says that this act basically responds to workplace hazards. And so that is just the reading and the textual interpretation that they're doing of this statute. And they're saying, throughout this statute the statute refers to workplace hazards, not all hazards, workplace hazards. And COVID-19 really isn't a workplace specific hazard. It's a hazard throughout the world, throughout everyone's waking day, whether they go to the grocery store or the gym or school, whatever it might be. COVID is a risk there, not just a risk at workplaces. And so that's what the court is saying. So they're saying because COVID is a risk that's not inherent to workplaces, the OSHA's Enabling Act does not give it the authority to act in this way. And so that's a very statutory argument in saying that, yeah, OSHA just didn't have the statutory authority from Congress to pass this ETS. And then the second argument, which is briefly endorsed but not explicitly endorsed in the per curiam decision, is essentially the major questions doctrine. And that is the idea that if Congress is going to give vast amounts of power to the agencies, it needs to speak clearly when it did so. OSHA hasn't enacted any type of requirement like this broad in its existence. And so the court is essentially saying, yeah, Congress didn't give OSHA this authority when it passed this law. And we don't expect Congress to hide elephants in mouse holes. Right, referring to the major questions doctrine very briefly in the per curiam decision. Now, more distinctly in a concurrence written by Justice Gorsuch, he talks specifically about this major questions doctrine. And what is it? Well, it's this idea, again, that Congress needs to speak clearly when it's going to give authority to agencies, and it didn't do so here. But then he also explains that the major questions doctrine is a cousin, it's a close relative of the non-delegation doctrine, which is this idea that Congress can't just abdicate its authorities to legislate to administrative agencies. No, the Constitution sets up a structure where we as citizens elect these representatives to Congress, in the idea, this idealistic idea that they're the ones who create our law. And so we can't, these big decisions, Congress can't just give those away, is essentially this non-delegation doctrine. And so how does the major questions doctrine relate to that? Well, it says in these scenarios where it's just vastly significant, billions of dollars of compliance risk here associated with this. In those types of scenarios, Congress has got to speak really clearly. Had Congress passed an act that said OSHA will has the authority to pass vaccination regulations and put those into effect. Okay, well then Congress has spoken clearly. But here we have an act that was written decades ago, and it doesn't look like it was all that clear that Congress was giving it this authority. And so Justice Gorsuch, puts a button on it essentially by saying, whose decision is it? Is it Congress's decision, or is it the administrative agency's decision? And he says, yeah, our Constitution sets up this structure where big decisions are for Congress. Now there's, of course, a dissent. It's written by the liberal bloc of the court, and it is a well-reasoned decision. It starts with first, just kind of putting an exclamation point on the idea that this isn't a vaccination requirement. It's a vaccination or test requirement. You don't have to get vaccinated if you don't want to. And so that's the first thing they point out. The second thing, contrary to what Justice Gorsuch frames it as the administrative agency versus Congress, this liberal dissent frames it as it is the courts versus the administrative agencies and the experts essentially. And so they're saying, no, the majority, you're not really policing this line. You're just taking the power for yourself. And that's not what is meant to happen here. You're unelected, life tenure judges. You're not folks that are supposed to be getting this power. This Congress and it is politically accountable, but the administrative agencies may not be quite as politically accountable, but they still are because they're run by President Biden, who was elected, right? So they're saying there's the political accountability, there's a shorter line in the administrative agencies than there is in the courts. Essentially, that is one of their large arguments. The next is that this is a grave danger, and it's necessary to prevent, further public health crises. So this emergency temporary standard is explicitly endorsed and authorized by OSHA's Enabling Act. They're saying statutorily this is fine. They say, you talked about this majority where it's like you said that OSHA's given the authority to deal with workplace hazards. Well, OSHA deals with hazards that are hazards inside of the workplace and outside of the workplace all the time, like fires, faulty electrical wiring, good drinking water, these types of things, right? Those are hazards inside and outside. So you're kind of drawing this line in an arbitrary way, is the argument of the dissent there. And so this really does just come down to a functionalist versus a formalist divide. And you have the formalists are the conservatives, where they're saying we're going to police this boundary of non-delegation of major questions fairly strictly. Whether they would police it as strictly if this was a conservative regulation remains to be seen. I think that's a fair criticism, but not completely fair yet because we haven't seen it. And then the second is you have these functionalist ideologies pervading the dissent, which is basically this is a serious pandemic. Hundreds of thousands of Americans have died, and we have to be able to do something to confront this. Congress might not be able to get it done, but President Biden was elected by the people, and let him get something done through the wings of the administrative state. And so you can see the divide. This really is a balancing act, and I think that this could get distorted really quickly if you just try and look at this through a legal realist lens, which it might be easy to do, and try and dig a little bit deeper. Try and look into the legal reasoning here and try and make sense of that would be my advice, rather than just getting divided over political ideological lines on something that's as controversial as this emergency temporary standard. So I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.